As you all may know, Senator Harp challenged me to a debate because he said this proposal I had was unconstitutional. We're about to run out of time, so I'm gonna get down to it. One of the reasons why he claimed it's unconstitutional is that he claims it creates two separate subclasses of taxpayers. He claims that because one system will be retired under this, nobody else can get in it, so it's closed, therefore it's not an active system, but it will have citizens who have a $13,500 exemption in it. There'll be another active tax system, the only one people can get into, that has a $20,000 tax system. He claims that's non-uniformity. Those are two separate exemption rates. Well, I've got some news for you. First of all, we have many different exemption rates in this community. The standard exemption rate is $13,500, as I've just mentioned. However, in 1991, you all voted in a senior citizen exemption rate of $21,500 under local legislation, which is precisely what this proposal would be. I didn't see Mr. Harp running down to the courthouse to file any lawsuit about that perceived non-uniformity. Disabled veterans get a $70,400 exemption. Hadn't seen any lawsuit about that. Firefighters and police officers killed in action are completely and 100% their families exempted from all property taxes. Military persons killed in action, their families, $43,000 exemption. We have several urban service districts which tax us by geographical boundary at different millage rates. And so there are many different exemption levels, and the Supreme Court of Georgia and the Supreme Court of the United States require only that there is a rational basis for that classification. The rational basis that I have stated and provided for you is a new tax system, one that lets us take advantage of our growth, one that does not discriminate against those who wish to purchase a home of their choice for their period of life, one that doesn't discriminate against welcoming strangers, and so forth. So let me just say what the standard is that Mr. Harp will have to meet when he gets to the Georgia Supreme Court, should he unwisely choose to challenge what I hope is going to be put on the ballot so you can vote for it. And this is it. Now, don't forget, legislation in this case will actually be the ballot initiative that you're voting on. So in this case, you all are actually legislators. You're ratifying what the state legislation has said, this proposal that I've put on the table. And this is it. This is the standard. In taxation, even more than in other fields, legislatures possess the greatest freedom in classification. There is a presumption of constitutionality which can be overcome only by the most explicit demonstration that a classification is hostile and oppressive discrimination against particular persons and classes. The burden is on the one attacking the legislative arrangement to negate every conceivable basis which might support it. Now, do you think I've proposed something that there's not a single conceivable basis that can be supported? Do you think these lawyers and these people who specialize in tax legislation and tax law? I don't think so. I don't think so. But guess what? We've got 14 months for you to weigh the pros and cons. And there's more. I want to also say about having two tax systems. Guess what? We got two tax systems right now. I purchased my car in 2007. I pay the birthday tax, right? I go in, I pay $250 on my birthday. If you bought a new car recently, you paid your tax before you left the lot. Two systems. Guess what? You could not get into my system because you bought a new car. My system is retired, and I'm in that system. I'm in that system until I buy a new car. And I didn't see Mr. Harp running down to file a lawsuit to declare that tax system unconstitutional. Nobody's challenged that. So, folks, this is the way people do business. They retire tax systems all the time so we can move forward as communities together. I did not have the opportunity to work with Mr. Polleys because he retired in 2002, and so of course I missed him by some 8 or so years. But I have had the opportunity to read his memos, and just want you to have a high comfort level, again, related to this debate and any question of the legality and constitutionality of the proposal on the table. The law he cites is thus. Tarver versus Dalton, 1910. In that case, the city of Dalton contracted with Mr. Tarver to exempt him completely from property taxes if he would give the city some water rights. You can't create a tax system for one person. Completely inapplicable. Griggs versus Green. The state revenue commissioner decided to order a couple of counties that they had to apply a particular percentage tax rate to certain kinds of property throughout their county. And the Supreme Court, no big surprise, said you don't have any General Assembly legislation for this. No voters have voted on this. The revenue commissioner has no such authority. It's unconstitutional and it's disparate. Hutchins versus Howard. The Supreme Court uses the word collusion throughout the whole opinion because in that county, the officials decided they needed to raise revenue by 15% to make their budget. So they had officials go out and pull property owners' tax returns and apply different tax percentages to different types of property, quote, without investigation or assessment to reach an overall taxation increase of 15%. Guess what, folks? Big surprise. That's not legal. So those are the three substantive cases upon which he claims that this proposal is somehow unconstitutional, doesn't fly at all. Then related to the non-severability issue, let me just state this. There is a presumption at law that if a piece of legislation is ever ruled unconstitutional by the court, some fragment of that the entire thing is therefore unconstitutional. So the way lawyers and parties have come up through time to try and save an overall broad scheme is they add into the legislation what they call a severability clause. And they say if any sentence of this is declared unconstitutional, we're asking the courts, please, to not throw the baby out with the bathwater. Please keep the rest of it, okay? That's not us. That's 180 degrees from what we're talking about. It's the exact opposite of what we're talking about. The case law that Mr. Polley cites in his memo are talking about those circumstances. What we are doing is saying if any sentence of this, any phrase of this is declared to be unconstitutional, we are putting it in writing that we want you, the court, to invoke the common law rule that the whole dang thing is null and void and thrown out. So we've got the common law rule, and then we've got an expression of voter intent that we want the common law rule that the whole thing is null and void. So unlike the other cases Mr. Polley cites, where there's successive legislative repeals, in this instance, what would be happening is it would be the court declaring it unconstitutional, void ab initio, as the lawyers like to say, and therefore it never happened. And that is the only way I would put this before you because, as I said, I solemnly believe that the property tax freeze is a pact to those that have relied on it. And in fact, in the Supreme Court in the Nellinger case said that there's two things that you must look at. Is one, are you protecting those who have a class or a class of persons who have relied on the system you're trying to retire? And are you putting new people on notice that there's a new system? Yes, indeed. That's what we're doing. That is a United States Supreme Court case, and that's the basis of the legal validity of the proposal that I'm putting forward.